I, Shashank Mishra, the host, welcome you to the fourth episode on Law and Life on the topic of noise pollution caused by Azan and other religious events. I will be having conversation with the renowned senior advocate of the Supreme Court of India, Subodh Markandeya. Thank you, sir, for joining this session. So my first question is, I learned that in 1970, when the idea of using loudspeaker for Azan in mosque was mooted, ulemas rejected it as a voice of Satan. Now they don't want to give up the use of loudspeakers, leading to endless controversy that threatens public order. Why don't we make laws and why don't we courts pronounce judgment on such important issues?
Shashank, your impression that there is no enacted law or that there are no judgments on the subjects is not correct. The Environment Protection Act of 1986 has been on the statute book for the last 36 years. Invoking that act, late Mr. M.C. Mehta, an advocate and well-known environmental activist, had moved the Supreme Court a number of times and obtained numerous directions, including those relating to noise pollution. He did pioneering work in the field of environmental protection. Under the orders of the Supreme Court, the direction on noise pollution were converted into statutory rules. Those rules are called the Noise Pollution Regulation and Control Rules 2000. So these rules have also been in existence since last 22 years. Those rules deal with every conceivable aspect of noise pollution. There are numerous judgments of the Supreme Court and the High Court on the subject dealing with the regulation and control of noise pollution. What is lacking is the enforcement of law, enacted as well as declared by the courts. Yes, Shashank. Next question.
Sir, please tell us about the leading judgment what they have let down.
The first judgment is of Calcutta High Court in Maulana Mufti Saeed Muhammad Noorul Rahman Barkati versus State of West Bengal. It's reported in EIR 1999, Calcutta. I think page is 1527, but it requires checking. In that case, the petitioner, who was the Shahi Imam of Tipu Sultan Mosque of Calcutta, filed a writ petition in the Calcutta High Court under Article 226 of the Constitution. He specifically claimed that it is his fundamental right to give azan on loudspeakers and prayed for striking down of noise pollution control rules which stood in the way of his enjoyment of fundamental rights. So this is a ruling which is pat on the point, as we say. The Calcutta High Court issued notice on his writ petition, but on the finding that though right to azan is integral to Islam, the loudspeakers are not integral to Islam, as they are the innovations of modern science and did not exist when the Holy Quran was revealed to the Prophet. Consequently, the High Court gave interim relief to the petitioner that azan may be performed without any let or hindrance or interference, but without the use of loudspeakers, as people in the neighborhood are entitled to their sleep. Students are entitled to study in quiet atmosphere, and the old and sick persons are also entitled to rest without noise. These are all aspects of right to life under Article 21 of the Constitution. As noted in para 28 of the final judgment of the High Court, the petitioner flouted the order of the High Court throughout the pendency of his writ petition by using the loudspeakers for azan without any regard for the people and their needs in the vicinity, their right to sleep, their right to study, and their right to quiet by the sick and old people. At the final hearing of the writ petition, the division bench of the Calcutta High Court upheld the constitutional validity of noise pollution control rules. In view of the persistent disregard of the interim order of the High Court by the petitioner and other mosque authorities throughout the period of pendency of the writ petition, the High Court directed the Commissioner of Police, Calcutta, and the superintendents of district police to confiscate all the loudspeakers from the mosques of the state and file a compliance report in the High Court. So the order of the High Court, I think, became final because apparently no appeal appears to have been filed. Now let us come to two decisions by the Supreme Court which are clear. In Church of God versus KKK Majestic, which is reported in 2007 SCC at page 782, the Supreme Court held, this is what I am quoting, there is no fundamental right to loudspeaker protected by Article 25 or Article 19(1)(a). On the contrary, violation of noise pollution rules is a violation of Article 21. Now, there cannot be more categorical statement of law than this. Now, the next case. In noise pollution number 5, reported in 2007, 5 SCC 733, the Supreme Court ruled, I quote, loudspeakers and amplifiers or other equipment or gadgets which produce noise pollution, once detected as violating law, should be liable to be seized and confiscated by making provision in the law in that behalf. Can there be more categorical statement of law than this? But even in the teeth of these clear declarations of law by the final court of the country, numerous writ petitions are being filed in various high courts from time to time, in which precious judicial time of the high courts is wasted when the issue has been finally adjudicated by the Supreme Court. Now, therefore, the final declaration of law by our apex court is absolutely clear. The problem is about the enforcement. The present ugly controversy in Maharashtra is also because of the failure to enforce the finally declared law of apex court, which is binding on all the courts throughout the territories of India under Article 141 of the Constitution. I may add here that under Article 144 of our Constitution, all civil authorities, including all governments, police, and other authorities, are under a duty to act in aid of Supreme Court. Recently, an extremist organization has issued an open threat not to enforce the law. Therefore, awareness about the true constitutional position and the courage to get the law enforced is the need of the hour. In contrast to the extremist, Mr. Najmul Huda, an IPS officer, writing in the newspaper called the Print, dated 23rd March 2021, has advised the Muslims to give up the claim of Azan on loudspeakers. He further added that even Prophet would have given it up. So the position is very clear. There is no ambiguity. That's it. There is nothing more I have to say.
Thank you, sir. Thank you. I hope this will answer all the questions on this contemporary issue. And with this, we will end this session.
Thank you, Shashank. Thank you very much.